Hello, precious viewers. This is Gwungmijana Legal Discourse for Law of Evidence 2. Law of Evidence 2 series. This video is my second video on character evidence. So the topic for discussion is character evidence, and this is the second video. In the first video, I ended the discussion with character evidence in civil proceedings. So if you have not seen the first video, do it to see so that I can flow logically. In this video, I shall be discussing character evidence in criminal proceedings or cases or trial. Character evidence in criminal. In the first video, I've discussed character evidence in civil cases. So the first question is character evidence admissible in criminal proceedings or criminal cases? Well, there's no straightforward answer, because when you are even giving a particular answer, the answer will still be subject to exception. But it can first be said that evidence of the take note that character evidence in criminal proceeding is more concerned with the accused. It is evidence of the accused that is relevant when discussing character evidence in criminal proceedings. So it can be said that evidence of the accused good character is admissible generally, while evidence of the accused bad character is inadmissible generally. That's the first answer that can be given, but it is also subject to exceptions. Therefore, it can be better answered if it is considered under 2-heading. So we shall now consider character evidence in criminal proceedings under 2 heads: evidence of the accused good character and evidence of the accused bad character. Just like the way the topic was considered, just like the way we consider character evidence in criminal and civil proceedings while trying to answer the question whether character evidence is admissible. And to better answer it, it was suggested that it should be considered under 2-8, criminal and civil. Now in criminal again, to answer it properly, for the answer to be clear, it will be better to also look at it under evidence of the accused bad character and evidence of the accused good character, the accused or the defendants. So in this video now, we shall look briefly at evidence of the accused good character. Then subsequently, we shall also look at evidence of the accused bad character. So the question now is evidence of the accused good character admissible? Guess what? What do you think? Yes, evidence of the accused good character is admissible. You know, the law always tries to protect an accused person, the law always tries to protect him. The law is always in favor of the accused. So simply, evidence of the accused good character is admissible. In fact, the answer is not without basis or backbone or support. The answer has a very solid foundation. The answer flows from a very solid foundation. It's resting on a solid foundation. And that is, the foundation is the Evidence Act. The answer is provided by the Evidence Act in section 81 of the Evidence Act. The answer was provided that evidence of the fact that the accused is of good character is admissible. Let's actually hear from the OSISMAT section 81 of the Evidence Act. Answer the question. Is evidence of the accused good character admissible in criminal proceeding? And section 81 put it succinctly and clearly, thus without any ambiguity or unequivocation. It put it thus: in criminal proceedings, evidence of the fact that a defendant is of good character is admissible. As simple as that. Evidence of the facts that the defendant is of good character is admissible. You can see, as simple as that. So the straightforward answer in relation to evidence of the accused good character is that it is admissible. And the reason is not unconnected with the fact that the law will protect the defendant or the accused. So this is just basically evidence of the accused good character. It is admissible as the law succinctly answer the question. However, it is important to note that the question of relevancy also arises in relation to evidence of the accused good character. So it has been observed that evidence of the accused good character should be evidence of his good character which is relevant to the nature of the charge, which is relevant to the fact at hand, which to the case at hand, to the charge at hand, to the crime with which or for which the accused is charged. So if you are using or giving the accused to give evidence of his good character in criminal proceeding, it will not be general evidence of his good character that is not relevant to the charge before the courts. So, for instance, now if the accused is charged with stealing another person's property, the accused is now giving evidence of how he is always of his skillful and kind attention while dealing with people. If the accused is not giving evidence of a skillful and kind, careful attention while dealing with people, the evidence may not be relevant. Such evidence may be, or while doing things that is always careful in doing things, attentive to what is doing. That evidence may not be relevant to that fact of stealing, but it can be relevant if the accused is charged with negligence, for example, manslaughter, which suggests negligence. And if the accused is now giving the evidence of how he is always careful and attentive to matters, then it will be relevant, not in the case of stealing. In the case of stealing, now the relevant evidence of the accused will be any evidence of his good character in relation to being honest. In relation to being honest, that the accused is always honest and sincere, may be relevant to the charge of stealing. So it is important that evidence of the accused good character should be the good character that is relevant to the charge. Otherwise, it may still be inadmissible by the rule of relevancy. So that the fact that they say, oh, the accused can give evidence of good character, then if the good character is not connected to the fact in issue, to the crime charge, then evidence of that good character is irrelevant. And there are some illustrative cases. For instance, in R against Turner, there the accused was charged with treason. So the accused in this case was charged with treason, and the court held that such evidence of the accused good character should not be general. Look at the court is giving a caveat there, a clause there, that the evidence of the accused good character should not be general, but should be limited to his character for loyalty and being peaceful. So in a charge of treason now, treason is where a person is trying to levy a war against the states. So a person that is trying to levy a war, overthrow the state, is suggests that the person has a violent character, a violent nature. So the relevant evidence now would be evidence of his character of being loyal. That means it's not such a violent person that will try to overthrow the state, or his character of being peaceful. So that's the evidence that will be relevant in a charge of treason, and not how the accused always pay his tithe every day, every week that he pays his tithe. It's not relevant to this charge of treason. So you can see also there's also the case of Arrow against Williamson. Arrow against Williamson, where the rule was reiterated by the court, which or the case also illustrates this point. In that case, a male midwife was charged for manslaughter. So in this case, now, a male midwife was charged for manslaughter. The male midwife was allowed to adduce evidence of his kind and skillful attention to other women. So he adduced evidence to the effect that, oh, he was always a kind and skillful while dealing with other women. So you can see now, as a contract distinction, if the accused was now giving evidence of how he was always honest, being truthful, it will not be relevant to this case that suggests the case manslaughter, killing by negligence is suggesting manslaughter is suggesting negligence. So it is evidence of the accused good character that has to do with paying attention, or being careful, or being reasonable in his acts, that is relevant, and not any other evidence. So you can see there's the cases supporting the fact that evidence of the accused good character must be such that is relevant to the nature of the charge. Otherwise, if the accused does not have any good character that is relevant to the nature of the charge, then it will not be able to give evidence of his character. So this I will stop here. Then subsequently, we shall now look at evidence of the accused bad character. Now this one is evidence of the accused good character. Later on, we look at evidence of the accused bad character. And see you